Oh, yay, oh, yay, oh, yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. Good morning to council and to everyone. Welcome, and to council, thank you for agreeing to make your arguments today virtually. Also want to welcome those of you who are watching by live stream on our YouTube channel. This is the November 2021 Jackson docket for our Tennessee Supreme Court. We've been conducting our hearings over Zoom for over a year now, and we're doing this to keep our system moving and to protect those of us who are participating in the system. We hope those of you who are watching online will make this a learning experience and use this opportunity to learn about our Supreme Court and our justice system as a whole. In just a moment, we're going to begin the first case by having Mr. Hibner call it out. When we do, each side will have 30 minutes for argument. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. Mr. Hibner, you may call the first case.
Tommie Phillips versus State of Tennessee.
Ms. Holland.
Good morning, Your Honor, and may it please the court. My name is Josie Holland, and by appointment of the Shelby County Criminal Court, I represent Mr. Phillips. Ms. Valerie Corder also represents Mr. Phillips on brief, and Mr. Roberto Garcia represented Mr. Phillips on appeal. I would like to say that I'm honored to be before this honorable court, though I am saddened that we have lost one of its members. But we are before this court today on a denial of a petition for post-conviction relief by the trial court, which the Court of Criminal Appeals affirmed. We ask that this court reverse the lower court's decision and find that Mr. Phillips deserves relief based upon his post-conviction claims. And in asking this, we're going to broadly be discussing three topics. The first is that this court should adopt Kimmelman versus Morrison as the appropriate standard to be applied when a petitioner has raised an ineffective assistance of counsel claim that a constitutional right was not previously asserted by a motion to suppress when the matter initially was considered before a court. And in adopting the Kimmelman versus Morrison standard, we're going to ask that this court eschew the standard announced in Cecil versus State, a lower court opinion from 2014, which is unpublished. The second topic that we will be discussing is that we're going to ask this court that Mr. Phillips has met his burden under Strickland versus Washington to show that he both received deficient performance of counsel and that deficient performance of counsel prejudiced the outcome of his matter. And finally, Your Honors, this court should find that there was structural error in this matter because Mr. Phillips has proven, whether by a preponderance of the evidence or clear and convincing standard, that he was arrested at noon on December 9th, 2008, and he was not formally charged until 52 some hours later on December 12th at 4:51 p.m. Turning to the first issue.
Ms. Hall, this is Justice Lee, and let me ask you this. It appears that the Court of Criminal Appeals did not follow Cecil and did rely on Kimmelman, and it seems that the state agrees that Kimmelman is the appropriate standard. So my question for you is, assuming that we adopt Kimmelman, how does that analysis flow? Can you give me a flow chart as to how that analysis would apply?
As to how the analysis in Kimmelman would apply.
Because I think your argument that we should adopt it, maybe your time would be better spent explaining how it would apply under the circumstances that the CCA already relied on it.
Well, what we're looking for that Kimmelman does that Cecil does not do is a disaggregation of the two prongs of Strickland. In Cecil versus State, Your Honor, the appellate court stated that both prongs of Strickland needed to be proven by clear and convincing evidence.
Right. And everyone seems to understand now that that was wrong in Cecil and that you proved the underlying facts by clear and convincing evidence. But the other issues that does not apply to the legal issues.
The legal issues that.
Right.
That the facts that the deficiency prong should be proven by clear and convincing evidence is what Kimmelman says. And after looking at whether or not the petitioner has established that something could have been filed, the question becomes next is should it have? Could they have filed it, and should they have filed it?
Ms.
And
Holland,
in
this
this situation,
This
Mr.
is
Honor?
just, I'm sorry to interrupt you, but this is where I have problems. We have a statute that says in our post-conviction, the facts should be proven by clear and convincing evidence. And there are all sorts of cases in the Court of Criminal Appeals and other places where they kind of conflate all that and talk about proving the other two factors, proving deficiency and prejudice by clear and convincing evidence. We know that's wrong, but I guess what I'm having trouble with, as a trial judge, I did many of these, and I don't remember. I just looked at it to see, is there deficiency? I don't know that I ever looked to see, is that being proven by preponderance or clear and convincing or beyond a reasonable doubt? I just said, yes, there's a deficiency here. And then the second prong is, is there prejudice? I don't know that I ever even applied a burden of proof. Maybe I was supposed to, but we're just looking at if there's deficiency, then you look and you say, would the outcome of the case have been different but for that error by counsel? Isn't that all we're really looking for here?
Yes, Your Honor, that is precisely what we're looking for. And in this matter, trial counsel admitted that it is his general practice to challenge 48-hour holds, that it was his office's practice to challenge 48-hour holds, and he provided no strategic reason for why he did not challenge it in this situation, nor could prior counsel. And from what the trial counsel said during the post-conviction hearing, it sounds like he believes that there was a meritorious Fourth Amendment claim here that he probably should have raised. And applying the Kimmelman versus Morrison standard, once we see that counsel has not done what counsel was supposed to do, then we look to see whether or not that outcome would have had a reasonable, whether or not the deficiency of counsel, whether there's a reasonable probability that that deficiency affected the outcome of the case, specifically whether or not the petitioner would have received a more favorable verdict or sentence. In this case, the petitioner would have received both.
Ms. Holland, this is Justice Bibbins. I'm kind of going back to Justice Lee's point about, let's talk about the application of that to the specific facts here.
Yes,
And I guess my question to you is, you're focusing on the 48-hour hold that had been the practice in Shelby County for a long time. I think all of us understand that was a very problematic situation. But in this instance, isn't it true that with this defendant, there was probable cause almost from the outset when they detained him based upon the identification by a witness and by his own confession?
no,
Which
Your
is
Honor,
unlike many of those instances when the 48-hour hold's there, when they're simply keeping the person there in essence to gather information to obtain probable cause.
No, Your Honor, I would not agree that there was probable cause for premeditated first-degree murder at the time that the 48-hour hold was entered, which was what he was detained, the charge specifically within the 48-hour hold, Exhibit 2 in the record, which was what he was detained for. There was not probable cause for that.
Ms.
Well,
Holland, when do you say that
counsel,
it
this is,
started?
oh, I'm sorry, go ahead.
When do you say that the 48-hour hold started? That might be a good way to start this out. When did it start? What time? What
The
day?
48-hour hold started at unquestionably no later than 12:40 p.m. on December the 9th.
December 10th.
December 10th, excuse me, yes, Your Honor.
Okay, when he was taken into custody.
When he was taken into custody, yes, Judge. He was
Okay.
actually arrested by an entire MPD tactical unit out in the field
Right.
a little bit earlier, but he was booked into 201 Poplar, we can say for certain, at 12:40 p.m. because those times appear both on Exhibit
Okay.
1 and Exhibit 2 of the documents.
Now you may answer Justice Kirby's.
Yes, thank you, Justice Lee. Ms. Holland, here's what I'm struggling with. You don't have a Gerstein issue here. Because there was an official probable cause determination within 7 hours after he showed up. So what is your best authority for a situation like this where clearly there was a probable cause determination within a short period of time, an official judicial probable cause determination? And he was under arrest, but not formally charged. I mean, how is that a suppression? What is your best authority for what the remedy is in a non-Gerstein situation like this, for what the lawyer should have done and how it would have made a difference?
Respectfully, Your Honor, we would disagree that there is not a Gerstein issue here. While a probable cause statement was obtained within 48 hours of Mr. Phillips coming into arrest, the 48-hour hold itself was violated and a formal charge was not brought within 48 hours of Mr. Phillips being brought into custody. And that is the requirement of Gerstein, not simply that a probable cause determination was made, but that formal charges were brought within the period of time in which Mr. Phillips had been in custody. Now, in the state's brief, they argued that they're not outside the 48 hours allowed by the order. The state argues that that should start at 7 at night, which is when they got this 48-hour hold, and we would disagree.
Well, the order recites that Mr. Phillips was arrested the same day as the order, does not recite the time. So the only time we have on December 10th is the timestamp on the order itself. And that's what you're dependent on, right?
No, Your Honor. Both on Exhibit 1 and on Exhibit 2, it states that Mr. Phillips was brought in at 7:40. At the top of the 48-hour hold itself, it states that Mr. Phillips was brought in at 12:40 p.m. on December 10th. So it's in two places in the record,
Thank you.
as well as in Volume 5, Caroline Mason's testimony.
Well, Gerstein doesn't reference a charging instrument. It references a probable cause determination. And he had that within that same date. I don't find any reference in Gerstein that there has to be a charging instrument, as in arrest warrant issued. Am I reading that wrong?
There has to be a determination that I believe so. Yes, Your Honor. I believe that Gerstein's holding is that he must be charged, that the 48 hours is the limit.
Can you point us to some language in Gerstein? Because I like Justice Lee, I'm looking at it, I don't see it right off the bat. Is there some language in Gerstein that points to when the defendant is charged as opposed to when there's a judicial determination of probable cause?
Gerstein holds that if there is a determination of probable cause, that the defendant can be held for 48 hours. However, that 48 hours is the utmost limit. And then once we pass that limit, there is a presumption that there has been a constitutional violation.
Well, I guess I'm having trouble seeing that the 48 hours was passed because there was a probable cause determination that day. And then but by that time he'd already given two statements. Then the third statement came on the next day within 48 hours. So, I mean, if the remedy for the Gerstein violation is to exclude a statement, both of his statements were given within 48 hours. So it's hard to see what could be excluded there.
We argue that the 48-hour hold itself is per se unconstitutional, Your Honor, that it creates perverse incentives for detention to occur, not only to occur before the 48-hour hold and then as well as after. And
even after there's been a judicial determination of probable cause? Why would that be per se illegal? Why, I mean, I'm not understanding, and I want to know your authority rather than just saying it's illegal. I want to hear some authority for why it would be illegal to hold somebody under arrest once there's been a judicial determination of probable cause, which took place 7 hours after he showed up at the station.
Well, again, Your Honor, we would contend that there was not probable cause for premeditated first-degree murder as is stated in the order, and that was in fact an error. But also, Your Honor, the warrant requirement is the gold standard here. And when a warrant is not gotten, there has to be, the arrest has to fall within several, within the exceptions to the warrant requirement. The police in this matter had an opportunity to get a warrant on December 9th. They had an opportunity to get it on the morning of December the 10th. They had an opportunity to get a warrant after Mr. Phillips spoke to police for the first time. And then they had an opportunity to get a warrant before they got the 48-hour hold. And
Ms. Holland,
in Rodriguez, sorry, Judge.
could we go
Yes.
back just one moment to the PC hearing? So say we adopt Kimmelman, and this goes before the trial court, and you've got essentially two claims, a Sixth Amendment claim, effective assistance of counsel, and a Fourth Amendment claim, search and seizure. Okay, so what's the very first inquiry this trial judge is going to need to make? What's the very first, in terms of a flow chart, what's the first thing that the trial court needs to assume? And we go back, are there any disputed facts in this record? There are?
There are disputed facts in this record, yes, Your Honor.
What are those disputed facts?
The disputed facts are the voluntary nature, whether or not Mr. Phillips turned himself in voluntarily.
What does that matter?
Why does that matter? Well, it seemed to matter very much to the trial court, Your Honor, but it
Okay.
also matters here because if he made himself amenable, to the police, then if he was there voluntarily, then the coercive circumstances created by the hold they are lessened. If someone is voluntarily there, then we don't have as much constitutional complaint. But Mr.
Okay.
Phillips certainly was not there voluntarily. He had been arrested by an entire tactical unit. His mother also in the police officer's car when he agreed to go in there with him.
Ms. Holland, this is Justice Page, and looking at this practically, I mean, if we adopt Kimmelman, then we're going to, in some cases, have a hearing within a hearing. The PC court will have to have a Fourth Amendment suppression hearing. Wouldn't it make more sense to just assume that there's been a Fourth Amendment violation and then look to see whether or not that it would have affected the outcome of the case? And if it would, then go back and have the hearing instead of calling in 4 or 5 witnesses where the defendant's going to have the burden of proof, however many you need. Wouldn't that be the way to handle these?
Well, as a petitioner, yes, Your Honor, we would absolutely love for that to be the way that this court would handle it. For us to say that, yes, there was a Fourth Amendment issue here, I think that would be the most instructive way to approach these sort of Russian dolls of a claim, right? You've got the Fourth Amendment within the Sixth Amendment.
Well, in
claim.
this particular case, I guess I would like you to address the prejudice prong, because we have 3 witnesses, eyewitnesses here, at least 2 for sure, and probably 3. So there's really no question about identity in this case. Then you have the Court of Criminal Appeals saying that, you know, even if there was error here, it's harmless because the guilt was just overwhelming. How is this court supposed to look at those matters?
When we're looking at the prejudice prong, Kimmelman instructs us that we need to look at the nature of the constitutional error as well as the pervasiveness of harm that has occurred in this case. And by contrasting Kimmelman and this matter, I think we can get something that's pretty instructive. In Kimmelman, there was a bad warrant and the contention was that a bed sheet should have been suppressed. And the court ultimately determined that might not have had a reasonable probability that would result in a different outcome of trial. But in this matter, what we're talking about is the Fourth Amendment as it relates to someone's seizure, to the notion that bringing someone into custody is a violation of their bodily integrity. And the error considered in the appellate court the first time around was a Fifth Amendment error. Respectfully, a different analysis, but when we're talking, the Fourth Amendment is more important or more protected than the Fifth Amendment. And we see this in Tennessee case law, specifically in State versus Rodriguez.
Well, Ms. Hall, let me interrupt you just a second, then you can kind of get cut to the chase here. Aren't you in essence arguing that your structural error argument is the prejudice?
Yes, Your Honor, precisely. That is
Okay.
my argument.
Then with that understanding, let's step back. Let's assume this court were to hold that it is not structural error. Can you show that there was prejudice without a finding of structural error in this case?
Yes, Your Honor, we can, because
what would
even
that
if
be?
the error was not structural, it was still constitutional, non-structural error, which would shift the burden to the state to prove that the verdict, that the suppressed statement did not contribute to the verdict. The burden would shift to the state. And that's specifically where we disagreed with the trial court judges, where they said that the burden in a post-conviction hearing never shifts to the state. We would argue that here it does, and that is how this court should approach it. The amici have addressed the first prong of Strickland pretty thoroughly, and I would like to address the last prong of Strickland with my remaining time, as well as address Justice Lee's question. We would, if I was going to map a flow chart for you, Justice Lee, to finally answer your question, is we would look at the merit of the Fourth Amendment first. What facts do we have in evidence to show that there was a Fourth Amendment violation? Here, that's very clear. We have the timestamps from the general sessions documents, and we have the times on the documents that are entered into the technical record of this matter. And those very clearly established that Mr. Phillips was not charged within 48 hours of being brought into custody, was not formally charged. And then we would look and say, well, did that cause harm? And here we can say that it certainly did. Mr. Phillips' statement, second statement given after the police had obtained the 48-hour hold, was far more inculpatory than his initial statement. And had that second statement been suppressed, we would have received a more favorable verdict as to particularly the burglary, the kidnapping, and the attendant felony murder crimes attached to them. One of the most distinct features in this case, and I think most evidence is prejudiced by reasonable probability, is the fact that it wasn't until after the 48-hour hold that Sergeant Vivian Murray went back to that arrest ticket, and where they had written first-degree murder, she then adds in her own hand and with her own signature, in perpetration of aggravated burglary. Because prior to the 48-hour hold in that second inculpatory statement, Mr. Phillips had insisted that he was there lawfully. Mr. Phillips had insisted that he came around there regularly because the younger son was selling drugs out of the house. We would ask that this honorable court, well, we've actually pled in the alternative. We would ask that this honorable court vacate the appropriate convictions for structural constitutional error. Also, we would believe that we went under a theory of constitutional non-structural error, that the state cannot prove that the statement did not contribute to the verdict. But we have also, if the court is not amenable to that particular form of relief, we've also asked that this court remand this matter back to the trial court for the court to apply the correct standard under either structural constitutional error relief or non-structural constitutional error.
If in your flow chart, if we find there's merit to the Fourth Amendment claim, then we go to prejudice. And then I guess we go to the Sixth Amendment, Strickland deficiency, Strickland prejudice, correct? If we find, if the first answer to the merits of the Fourth Amendment claim, if that is no, if we find there is no merit to the Fourth Amendment claim, which as I understand here is based on the 48-hour hold issue, then is that where the analysis stops? Is that the end of the analysis?
Well, if there is no Fourth Amendment claim, then counsel could not have been deficient for bringing it. But in this matter, counsel specifically stated that he believed that the 48-hour hold was unconstitutional, and that after reviewing the case and noting that he had not raised that previously, that was something that he thinks he probably should have done.
Well, this is Justice Bivens, Ms. Holmes, but the fact that the lawyer says that doesn't establish it, correct?
I would disagree with that, Your Honor. If it's one's
So
professional
if a lawyer
practice,
comes in and says he should have filed something regardless of the merits of it, that establishes a deficiency?
not regardless of the merits, Your Honor, but here we have very specific facts which do raise a meritorious Fourth Amendment claim in the opinion of the petitioner. And trial counsel is now a judge, a general sessions judge, and he would not have claimed that there was a meritorious Fourth Amendment claim if he didn't truly believe that. And if he's stating that it is his personal practice and what he believes the professional practice to be would be to have been to file a Fourth Amendment suppression motion in this matter, then that's what should have been done. And we respectfully request relief from this honorable court. Thank you so much.
Mr. Wardle, you may begin.
Thank you, Your Honors. Good morning. My name is Jonathan Wardle, and I represent the state of Tennessee in this matter. As I understand it, Mr. Phillips is before this court challenging the denial of his petition for post-conviction relief based on the alleged deficiency or ineffectiveness of counsel, which is based on the supposed failure to litigate a suppression issue, which was allegedly the failure to charge a Fourth Amendment violation and a Gerstein violation. Obviously, this has multiple layers. I like Justice Lee's flowchart concept. I'll point out that the court expressed a particular interest in the applicable standard governing the petitioner's burden to establish prejudice when the petitioner alleges counsel was ineffective for failing to litigate a particular suppression issue. So I want to walk through this flow chart, but I want to start with the point that Chief Justice Page made. I don't think the court has to go in any particular order as to the Strickland inquiries. It can look at the case and say deficiency might be easier to resolve it here, prejudice might be easier to resolve it here, and it can take either one of those. Starting off with this, so to speak, flow chart, or perhaps it's a tree diagram, however you want to look at it. There is no constitutional right to post-conviction review. It's a creature of statute.
This is Justice Page. Before we get to that, you can see that we should apply Kimmelman in these type of matters, right?
Absolutely, Your Honor. Yes.
And
Thank you.
do you think there are any disputed facts here?
Yes, Your Honor.
Okay. What do you think the disputed facts are?
Well, a couple that I caught during counsel's argument. When does the 48-hour hold start? When was the petitioner arrested? I'll point out that in the post-conviction hearing, petitioner came up with a story about the entire tactical team surrounding his house and all that stuff. At the suppression hearing at trial, he testified that his mother drove him in. That he turned himself in and she drove him to the police station so he could answer some questions. Two completely different stories. And there was, it absolutely wasn't clear reviewing the post-conviction testimony from the attorneys, the officers, et cetera, when exactly he was arrested.
So when do you say the 48-hour hold started?
Yeah, I think it's not clear. And the burden is on the petitioner to establish by clear and convincing evidence all of the facts. That's a fact.
All right.
But when it started, it's not entirely clear. I will point out that the post-conviction court in its findings of facts kind of punted on that particular issue, saying he was placed in custody at 12:40. And he turned himself in to answer questions. And then within 7 hours of that time, there was a Gerstein probable cause determination. Since that 7 hours clearly answers it, the court didn't feel it necessary to then, or apparently didn't feel it necessary to figure out exactly the minute. Because if that probable cause determination satisfies Gerstein, when the arrest started doesn't exactly matter.
Well, Mr. Ward, is that a sound approach? By the CCA?
Is which aspect of sound approach, Your Honor?
I said from the standpoint of basically not delving into the exact findings with regard to when the 48-hour period started, if in fact there was the probable cause hearing that solved any Gerstein problem.
Yes, that does solve the Gerstein problem, yes, Your Honor.
So, I mean, so why do you think that it was necessary for the CCA then to still delve into the exact time that the 48-hour hold started?
Oh, I do not, personally, I don't think it was. The state's position is it wasn't necessary because it solves the Gerstein issue. But to the extent that Mr. Phillips argues that that doesn't satisfy Gerstein, then it would have been necessary. If it didn't satisfy Gerstein, then you do need to nail down the exact time of the arrest to figure out when the 48 hours start and when it ends. We would also point out that if we're going by the 48-hour rule under Gerstein, the second statement was made the very next day. So even if that the trial or the magistrate's probable cause determination isn't sufficient, and it is, but even if it weren't sufficient, you've got the statement within the presumptively reasonable 48 hours.
So if it's a hearing within a hearing, which part do we take first?
Well, let's go back to that flow chart, if I may. I think that will answer the question. As Chief Justice Page said, you can address prejudice first, absolutely. But to walk through the various steps that need to be addressed. First, as a post-conviction matter, you have to allege a constitutional violation, and here it's ineffective assistance of counsel. The ineffective assistance of counsel under Strickland requires two elements. One is deficiency, one is prejudice. Under Kimmelman, there are two additional elements. When you're alleging the counsel failed to litigate a suppression issue. Those two additional elements, one is that the suppression issue would have been meritorious, and the second is a reasonable probability that the verdict would have been different absent the supposedly excludable evidence. So you've got those four different elements, all of which need to be met. And the answer, if the answer is no to any one of those, then the post-conviction petition fails. The ineffective assistance claim fails.
Counsel, this is Justice Kirby. I want you to comment because I had broken it down a little further than that under Kimmelman. And I want you to tell me, the purpose of this is for you to push back and tell me if I'm wrong about this. I'm just jotting down my initial notes on Kimmelman. My notes, my flow chart said, first, are the Fourth Amendment claims meritorious? And that's more fact-based. Then second, was counsel deficient in not including them in a motion to suppress? Because even if they're meritorious, for example, there may have been a strategic reason not to do that. So I have that broken down into a separate element. And then finally, is there a reasonable probability that the verdict would have been different had counsel included it in the motion to suppress? Comment on that if you would.
Yes, Your Honor. I think that is courts across the country have struggled a little bit with this. There's an Alaska case that I do not cite in my brief that does exactly that. It combines Strickland and Kimmelman, and instead of 2 prongs or 4 prongs, creates 3 prongs. I think the best approach is to do exactly what the United States Supreme Court did, which was said you have to meet both Strickland prongs, and that the second prong in yours is the deficiency. That's the first prong in Strickland. But again, it doesn't matter which order you address it in. And I agree, you can have a meritorious suppression issue that counsel decides for strategic reasons not to litigate. We want the statement to come in. So you have to address deficiency, and you have to address prejudice under Strickland, and you have to address the meritoriousness of the suppression issue under Kimmelman, and you have to address whether the exclusion of the evidence would have led to a different, there's a reasonable probability that it would have led to a different result of trial.
Okay, second question is, if I understood your opposing counsel correctly, she said that the burden on those elements is on the state. I may have misunderstood that, but I'd like you to comment on the burden of proof.
Yeah, I caught on to that also. And frankly, we disagree. In a standalone Fourth Amendment claim raised, before trial, there is a burden shifting that goes on. We're not in that posture. This is not a Fourth Amendment claim that is being raised before this court. It is a Sixth Amendment claim in the context of a post-conviction petition. On both of those, the petitioner always bears the burden. It doesn't shift. I would point this out.
Doesn't that bring in the amici issue and their argument with regard to whether in fact that is the appropriate burden of proof?
I guess I want to separate out two things really quickly. I don't know if it will answer your question exactly, but this is a good point to separate these two out. When we talk about the burden of proof, it gets a little dicey because it's a mixed question of law and fact, right? So there's the burden of proof as to the factual allegations. In the post-conviction context, that has to be by clear and convincing evidence. When we talk about that, that's by statute. And that goes to all factual allegations to support every one of those 1, 2, 3, and 4 prongs. But the legal conclusions are up to the court to make based on the clear and convincing facts. So I don't know if that exactly addresses the issue, but
But now I guess my point is, as I read the amicus brief, it seems that they are making the argument that because the burden in an original suppression hearing would be on the state at some point, there was a shifting of burden, that it should be essentially the same in a post-conviction hearing.
Yes, and I recognize that argument from the amici, but I disagree. I think under Strickland and under our post-conviction law, that's not the case. And again, it bears mention that this is not a Fourth Amendment claim. What is being litigated is a Sixth Amendment claim. In the context of the Sixth Amendment, the petitioner always has the burden of proving counsel's ineffectiveness. So yes, there does have to be, under Kimmelman, essentially a hearing within a hearing if you're going to reach the merits of the suppression issue.
So the facts have to be by clear and convincing evidence, and then the remaining issues are either straight legal issues or mixed fact and law issues, and would not be clear and convincing. Is that correct?
Yeah, as to the factual aspects, always clear and convincing. As to the legal aspect, no. And the way I like to look at that is you have all the underlying facts. Whatever facts the court is going to rely on have to be established by clear and convincing evidence. But those 4 questions, those are, all 4 of them involve reasonableness to some degree. That's the quintessential legal kind of, this is a legal issue for the court to decide.
Tell me your 4 prongs again.
You have the deficiency, prejudice, then Kimmelman adds to those meritoriousness of the suppression issue, and a reasonable probability that the verdict would have been different absent the excluded evidence.
How is that different from prejudice?
That is a good question. That is why the Alaska court, I think, condensed it into 3 instead of 4.
Well, but you break it down into 4, and so I want to suss that out and know why.
Yeah, so I break it down into 4 because that's how the United States Supreme Court articulated it.
Okay, but I mean, I'm trying to figure out what is the difference between the 2, and the Supreme Court is not here to explain. You're here, so I'm asking you.
No, as a practical matter, I think in almost every case, there will not be a difference. There may be a case where, for example, the tactical reason or counsel wanted it to come in. There may have been tactical reasons why, but that goes to deficiency also. That's one of the issues in post-conviction is all of these 4 prongs, or the 2 prongs in a typical claim, they interrelate.
Mr. Ward, this is Justice Page. I was struggling as I prepared for this with the same thing that Justice Kirby is talking about. I was trying to think of a scenario where if you had the 4-prong approach, it would meet number 2, but then not number 4. And I couldn't come up with one. Are you telling us that if you have a tactical strategy matter, that might suffice in that scenario?
But
guess
isn't
what
that,
I'm
I mean,
saying-
it isn't a reasonable probability of a different verdict. Isn't that just what prejudice means in this context?
Well, but the Kimmelman prejudice prong talks about based on excluded, would the result been different based on this excluded evidence? I'm wondering
Right.
if there is a situation where the verdict might have been different based on totality of circumstances or overall, rather than strictly limited to that excluded evidence. Honestly, I can't think of an example, but when I was preparing this, I kept imagining these circles, and there was a big overlap between those two prejudice prongs, but there was some things right on the edges here that didn't overlap, but I can't think of anything.
So I think,
Seems like if it doesn't overlap, it's not a Kimmelman. It's not a Kimmelman.
I think it has to overlap. I just don't know what is not in the overlap that might exist out there. That's what I was trying to.
Question.
Yeah, what's the Alaska case you mentioned, Mr. Wardell?
what is the, excuse me, I couldn't hear.
I'm sorry, I was asking, you mentioned an Alaska case that actually broke it down into 3 instead of 4. What was the Alaska case you're talking about?
Your Honor, I am sorry. I do not remember the name of it, but if you would like me to file a supplemental, I will do that this afternoon, just a letter with the name of the case and the citation.
Up to you. So.
I will go ahead and do that this afternoon. I'm sorry, I cannot remember the name.
Mr. Wardle, is it possible that the 2 Kimmelman hearing within a hearing elements fall under the deficiency prong? In other words, determine Strickland deficiency, we do the 2 Kimmelman factors under that analysis. And then if there is a meritorious Fourth Amendment claim and it's reasonable, probably it could have been different based on sort of evidence, then we can determine, was it deficient under Strickland not to have filed that motion?
Mm-hmm.
And then if so, then we drop down to number 2, the prejudice prong of Strickland. Now, we may have already answered that prong, but we would need to take a fresh look at prejudice as defined by Strickland based on those previous findings under the Strickland deficiency prong, which included Kimmelman.
Yes, Your Honor. So it makes sense. We're talking about different subsets in a flow chart, Venn diagrams. I searched a bunch of state law cases to see how they addressed Kimmelman, and some of them adopted the 4 prongs because that's what the United States Supreme Court said. Some, one, the Alaska court did it in 3. Some made Kimmelman a subset of deficiency. Some made Kimmelman a subset of prejudice. I think since it is a federal constitutional standard, I feel most comfortable presenting to this court that it should adopt the Kimmelman standard as stated. The 2 Strickland prongs, the 2 additional prongs. As a practical matter, it may be the case that the Venn diagrams overlap entirely, or maybe there's a tiny subset that we're having trouble thinking of right now that might arise in some wacky situation. But I feel most comfortable articulating exactly what the United States Supreme Court said in Kimmelman, which is 2.
It seemed like Kimmelman sort of threw the hearing within a hearing, threw those out there, but didn't really give us any guidance on the order of analysis. I didn't think. It said, consider this, but it didn't tell us in what order. So that was sort of my confusion. Or does it matter? It usually does matter how your analysis flows. You don't want to start at the back end and back your way into it. But I didn't think Kimmelman gave us that much guidance.
But Kimmelman does not put a specific order for the 4 prongs. And I think that's for the reason that Chief Justice Page alluded to earlier. In a Strickland claim, either or, you have to establish all of them. So if there's one that you can't establish, the claim fails. Same when you add in the 2 from Kimmelman, same thing. You have to establish all 4. If there's one you can't establish, address that one first and be done with it.
Yeah, okay.
So in this case, how does your analysis apply under the facts of this case?
Yes, Your Honor. I will Well, first, I don't think there's deficiency. And again, the factual issues, I simply do not read the post-conviction testimony the way that opposing counsel does. I don't recall the attorneys, and there were multiple who testified, I don't recall them ever saying, oh, I should have. I do recall them testifying that they often challenge the 48-hour holds. They did testify that they did not in this particular case. I don't recall any of the attorneys saying, oh, I should have. And frankly, on this case, it was so obvious. You know, the typical 48-hour hold case coming out of Shelby County, there was no probable cause determination. Here, there was one very quickly. So I don't think there's deficiency to begin with.
Well, are you saying, though, in saying deficiency, are you really saying there was no meritorious Fourth Amendment claim under Kimmelman? Are you talking about the Strickland deficiency prong?
I'm talking about the Strickland deficiency prong because in this case, it was so obviously not meritorious.
Okay.
Right. And also, even if it was meritorious, it so obviously wouldn't have made a difference. As has been pointed out, identity wasn't at issue in this case.
Well, what about on the, and I had not thought about this until Ms. Allen brought this up, on the burglary charges, you know, on the murder case, the attempted murder, the murder, yeah, but on those lesser charges, the burglary, for example, would it have made a difference?
No, Your Honor. Again, the claim here is a Sixth Amendment claim for failure to raise a Fourth Amendment claim, and the statement should have been suppressed. This, whether another charge should have been brought or not, is a completely, wholly different issue. I don't think there's anything improper with the state continuing to investigate and making charges. In fact, the reason the police officer testified that they were trying to find the appropriate charges because Mr. Phillips alleged self-defense. He claimed self-defense. So they were trying to find the appropriate charges. There was probable cause for his arrest, no question about that. Probable cause, both the police had it and the magistrate determined on their own that they had it. That's not an issue. But you're not bound at the moment of arrest well, you can only charge them. I mean, that's just not an issue in this case.
Well, the statements didn't have anything to do with he did not mention the rape, sexual battery, aggravated burglary, any aspects of those crimes in his statements, did he?
He did not, but the victims talked about that. We don't expect the defendant to confess to every aspect of their crimes. That's just
no. I'm just saying, if you're looking at prejudice based on, if you find there's a meritorious claim, you look at the statements. I don't see that the statements deal with anything other than the stabbing and the grandmother's death.
Yes, correct, Your Honor. In fact, that goes to the next step. I was going to say, so we have no deficiency, but then if you look at the whether the prejudice, well, I guess I don't want to say the next step. Another one of the steps is the prejudice inquiry and the reasonable probability that it would have affected the verdict. And here it wouldn't have. Identity was never an issue. And the victim's testimony was, I mean, this was a horrific set of facts. We're talking about multiple hours spent in a home, stabbing people, strangling people, raping people, the things that he said, it's awful. And the way I read the opinion on direct appeal was there was evidence not just from the victims, but then you have the first responders, the medical personnel, the autopsy, everything backs up what they say. There's even other witnesses who tell the police it was Mr. Phillips. Identity is not questioned. What happened wasn't a question, and the court on direct appeal said there was no Fifth Amendment error in admitting the statement. But even if there were, it was harmless beyond a reasonable doubt.
Well, and I have an issue with presuming no prejudice based on dicta in the direct appeal, because on direct appeal, the issue there was whether the statement was voluntary, and the court said no, it was voluntary, so no violation there. And then the court went on to say, but even if there had been a error in not suppressing that statement, it was harmless. I have real trouble saying, okay, well, they said it was harmless on direct appeal on a Fifth Amendment violation where the state had the burden of proof, and we'll take that dicta finding, bring it over here to a PC hearing where the petitioner has the burden of proof and it's a Fourth Amendment violation. Do you really think that this PC defendant or petitioner is precluded from proving deficiency based on essentially a throwaway statement in the direct appeal?
No, Your Honor, we do not argue that the Court of Criminal Appeals holding on direct appeal is dispositive here, but it is extremely persuasive. As Your Honor pointed out, the state had to prove harmless beyond a reasonable doubt and to get that holding. So for petitioner now to prove prejudice, they're going to have to find some way that this statement was prejudicial that wasn't considered before, and they haven't done that here.
But
And
this is Justice Kirby, we don't really need to gunk up the analysis with all that, do we? I mean, it's pretty clear cut one way or the other without getting into the effect of the Court of Criminal Appeals dicta, right?
correct. It's not necessary. Again,
This is Justice Page. We could make our own assessment of whether these facts are overwhelming or not, regardless of what the CCA said in dicta, correct?
Right.
correct, Your Honor. Absolutely.
And
Well,
my question,
In fact, probably should, yeah.
my question is, if we determined that there was no Fourth Amendment violation here, that the motion to suppress, if it had been filed, would have had no merit. I think there was one filed, but this issue wasn't included in it. Do we stop the analysis there, or should we go on and outline the proper way to handle these cases after adopting Kimmelman?
Well, that is obviously up to the court, whether it should go on and address this and make a more broad, expansive, or a simple, narrow one. The state's position is this court should adopt Kimmelman. The standard under Kimmelman is fairly clear, remembering that it's within the post-conviction context. To answer the question asked by this court in the order granting the Rule 11 application, the burden of proof is petitioner always has to prove the underlying facts by clear and convincing evidence, but the legal questions are made by the post-conviction court and by the courts on appeal, de novo on appeal. And there's the 4 prongs under Kimmelman, and then applying them to this case, answering any one of them in the negative defeats the post-conviction petition. Here, it was not deficient, it was not meritorious, and there's no prejudice. Certainly, no facts have been established by which we could conclude there was any prejudice. I mean, there just was no prejudice.
And Mr. Wardle, this is Justice Page. You would agree with me that we talk about burdens of proof when we're dealing with fact finding and not with legal findings like is stated in some of the opinions that we read, right?
Absolutely, Your Honor. Those, as we pointed out in our brief, those are sometimes it has been articulated imprecisely as the language, I think, from Phillips, but yes.
Mr. Wardle, in your brief, you made the statement that the harmlessness finding on direct appeal, which dealt with precisely the same evidence Mr. Phillips challenges now, precludes a finding of prejudice here. Do you stand by that statement? Are you saying that the prejudice determination here is precluded by what the Court of Criminal Appeals said on direct appeal?
Your Honor, I may have overstated my hand. No, it is not precluded.
Okay, thank you. I sort of thought you had, but I wanted to hear it from you.
No, I apologize.
He needed to extract that from you, counsel.
It was a really good try. And actually, after when I read that, I'm like, well, does it?
No, I would love to say it's the law of the case, but it's not. It's a different case.
Okay, good. Thank you.
And I apologize. Yes.
Being a good advocate.
Unless there are further questions, we would simply ask this court to, again, adopt Kimmelman and affirm.
Thank you.
Thank you, Your Honor.
Thank you, counsel. Ms.
If I
Ms.
could
Holly,
just,
you may begin. Go ahead.
thank you, Chief Justice. We'd first like to say that whether by preponderance of the evidence or by clear and convincing, we have proven that there was a Fourth Amendment violation here. And while there is no constitutional right to post-conviction review, we are talking about the protection of our constitutional rights, specifically the Fourth and Sixth Amendment. And the federal Constitution is but a floor. And our Supreme Court has held that Article 1, Section 7 actually provides greater protections to defendants than the Fourth Amendment. I would also like to clear something up that I said during my opening argument, which is that Gerstein is not met when there's not a formal charging instrument issued within 48 hours. That is not a correct statement of the law. What I was trying to say was that in this matter, this order does not meet Gerstein, because what happened here was that the police set up a rule for themselves that they did not abide by. They issued the 48-hour hold for Mr. Phillips to be held from 1240 to 1240 on December 10th. It would be ridiculous to say that the 48-hour hold didn't start until it was filed at 7 at night. If we were to tease that out to an absurdity, someone could be held in a trunk for 8 days before getting a probable cause determination. And then once they got the probable cause determination, that's when the clock starts running. That would not be in accordance with prior law. This 48-hour hold does not comply with Gerstein because the rule that was set out was violated. Mr. Phillips was not released within 48 hours of being brought into custody. And
where in Gerstein does it address when the defendant is charged as opposed to when the probable cause determination is made?
In Gerstein talks about, that doesn't really discuss formal charging. Gerstein is more about the permissive nature of being allowed to have probable cause determinations as a means to hold defendants. And that,
well, doesn't it talk about holding a defendant prior to a determination of a judicial determination of probable cause?
Prior to being
am I misreading it? I thought that's what it referred to.
No, Your Honor. It's about a probable cause determination without the defendant's presence and without any adversary representation. And in that way, it is not as good as being brought before a magistrate. And in that way, it's also not as good as an arrest warrant being issued, which is, of course, the gold standard of the Fourth Amendment. We also would like to correct the idea that we created a story during post-conviction hearing about a tactical unit being brought in. It is true that Mr. Phillips, who has a very low IQ, and his mother did say that they brought him down to the police station during the motion to suppress, but that was based on the first round of discovery before the supplement of Officer Reynolds, which was made Exhibit 3 to the post-conviction proceedings, and outlines just how much trouble and how much time these police had to get a warrant, and chose not to, but before they arrested Mr. Phillips in the field. But for the 48-hour hold, that second statement would not have been given. And this court should assess what the evidence was without that statement. Had the statement been suppressed, the question is would he have been convicted as harshly, would have been sentenced as harshly without that in the record? And we submit that it would have not. We respectfully ask that this honorable court reverse the denial of post-conviction relief and vacate the convictions. Thank you.
All right. Thank you, counsel, for your good arguments. And thank you to all those who joined us on YouTube this morning. We're going to take a break and we will return at 10:30 Central Time to hear our second case today. Thank you.
The honorable court is now in recess until 10:30 a.m.